introduce our outstanding speakers, who are really great professionals in the sphere of business and human rights. And our first speaker is Claire Wright, and she is Associate Professor in Private Law, Vice Dean, and the founder and the Director of NOVA Center on Business, Human Rights and Environment at NOVA Law School in Lisbon. Our next speaker is General Letner Černić, who is the Professor of Constitutional and Human Rights Law at Faculty of Government and European Studies at New University. Our next great speaker is Nadia Bernas, who is Professor of Law in the Law Group at Wageningen University. Our next speaker is Harriet Moynihan, who is Associate Fellow in International Law Program at Chatham House. And our final speaker is Bogdan Carnău, who is Associate Professor of Department number 1 of Civil Law at Yaroslav Mudry National Law University, and he is also the co-director of joint master degree program on European and international business law. So let us start from our discussion from the first question, which considers the long-standing process of corporate sustainability due diligence legislation, which is under ongoing legislative discussion at the EU level for the last several years. And we will focus specifically on its impact on rule of law environment in different regions. So the first question for our speakers is, how do you consider the impacts and the applicability of due diligence requirements in different rule of law contexts? So, for example, if we have weak rule of law, would it be the same requirement for corporate actors to comply with due diligence requirements, or would you think that it is unfair treatment to require the same conditions and the same demands for different corporate actors in different sustainability and rule of law agendas? Yeah, thank you. And our speaker can just raise hands and we will give a floor to you. Yes, Claire?
Hi, first of all, thank you so much, Tamara. Thank you so much, Elena, for the kind invitation. It's a pleasure to be here. So in relation to the question that is extremely interesting, I think here it's important to think about also the sort of scope of application of that is imagined by the draft Corporate Sustainability Due Diligence Directive, the CS3D. I don't know if everyone in the virtual room is very familiar with the CS3Ds, but basically the draft directive aims to basically introduce legally binding obligations for large companies to exercise human rights and environmental due diligence throughout their supply chains. And in terms of the application, it envisages an application to large European companies, but also non-European companies that generate a certain turnover in the EU or for certain criteria. So it has that sort of scope of application that goes beyond just European companies. So that's the first point. And the second point that is relevant when we look at the sort of reach of the directive and the extraterritorial reach in particular is that by requiring the companies that are in scope of the directive to do their due diligence throughout the supply chains, I'm using the term supply chains here, it's been very controversial whether it should be supply chain or value chain, but the latest version of the debate is focusing on supply chain, which is why I'm talking about supply chains. And so in order for the companies in scope to fulfill their obligation, they have to require their business partners throughout their supply chains to also exercise their due diligence. And so there's trickle-down effect that goes way beyond Europe, and that is going to be extending throughout the supply chains across the globe, and including in places where the rule of law is weaker. Now, in terms of coming back to your question, Tamara, so what will be the implications on that? If we look at the sort of due diligence expectations on companies, when they in particular, when they contribute to adverse human rights and environmental impacts, or when they're directly linked to some such impacts, they are expected to use their leverage to affect changes in the practices of their business partners. But sometimes it also goes beyond that, or at least I would agree that it does, to also help make a change in the environmental, sort of in the operational context in which they operate. And we have seen that recently, for instance, in the case of the Football World Cup in Qatar, which was a challenging context for companies to operate with. There were a lot of sort of cultural and practical challenges to human rights of migrant workers operating, working in the building infrastructures of the Football World Cup. And here I think it's important to recall that the UN Guiding Principles on Business Human Rights also talk about that scenario where local context actually contradicts international human rights standards, and basically requires companies or ask companies at least to obey the sort of highest standard, to operate to the highest standard, to consider sort of additional standards compared to the one that are set by the national law in these countries in which they operate. That might not always be aligned with international human rights standards. Now, I do see that there is a role and a potential for human rights and environmental due diligence to sort of help improve this environment by this sort of leverage that companies should be exercising. However, this role can really be played provided companies do not interpret their human rights and environmental due diligence duties as a tick box exercise. And we have many studies that show that, for instance, audits, certification schemes, etc., are just not enough to trigger that kind of changes that we need and that we're talking about here today. So there is a need for an approach that is a lot more holistic, that relies a lot of stakeholder engagement to understand the challenges of the context and sort of help effect the changes from within. It's not an easy process. It's not something that will be quick, but I think here it's worth just reminding that human rights due diligence or environmental due diligence is not an obligation of results. It's an obligation of means, and the idea of continuous improvement here, I think, will be very important. And I will stop here to look forward to my colleagues.
Thank you very much, Claire. Yes, Nadia.
Yeah, thank you. I just saw an opportunity because you talked about, so first of all, thank you for inviting me. This is great. Because you finished with that idea of box ticking exercise, and how sometimes, often, companies will see the due diligence process as this. So I saw an opportunity to make the point I actually wanted to make on this question, which is that I think in the due diligence discussions, in relation to the Sustainability Directive, for example, but also in other due diligence legislation, I didn't see a lot of discussion, and certainly it's not really reflected in the text, or at least not strongly enough, this question of different environments, and the different environments in which this due diligence process needs to happen. I think in general, the draft is very weak on this and seems to be operating on the basis of a fiction, which is that companies control all their supply chain, and whatever environment they should find a way to identify and minimize their human rights and environmental impact. And yes, companies have leverage, and it is sometimes possible, but also I think we should acknowledge a little more openly that sometimes it's just not possible. And so I think the original question you asked, Tamara, was, is applying the same requirements to companies operating in different rule of law environments, is that fair? And for me, like, to answer this question, I would say that the requirements have to be the same, right? If we care about human rights and the environment, we cannot say, well, if you operate in that country, then that's okay. It's not okay. Like as a human rights lawyer, I strongly disagree with the idea that the requirements should be different. But on the other hand, we can also see that in some environments, which we can say have weak rule of law, there is, for example, it's very difficult to engage with civil society, to conduct the consultations, to set up a proper due diligence process. If you have a situation where civil society is non-existent or very weak, through, of course, no fault of the people of that country, but for various reasons, maybe because there's a conflict situation, or maybe because human rights defenders are being persecuted. And we know, unfortunately, that there are many countries where that happens. So when this process of engaging, to take just one example, but when that process of engaging with civil society is just not possible, then it's clear that the due diligence process cannot happen. And therefore, so for me, that should lead to, well, then that means there's no possibility to safely operate in that country or in that environment. But unfortunately, what we see is that often companies interpret that as, well, there's no civil society to talk to, so the state wants us there, so that's okay, we'll just stay. Now, I know there are all sorts of issues about responsible disengagement in the context of the conflict, etc. So that's a little different situation. But by and large, what we see is that when there is weak rule of law environments, companies continue to supply, or European companies continue to supply from there, and just say, well, we can't really do that process, so we're just going to stay anyway. So I would say that they shouldn't, and that if we interpret the due diligence standards properly, in my view, that should lead to these kind of results. But I'm not seeing it now.
Thank you, Nadia, for your comment, and I give the floor to Harriet.
Thank you very much, and thank you very much for inviting me. And I had the pleasure of attending a little bit some of the first seminar on the rule of law, which I found really, really interesting and helpful. So thank you for that. So perhaps just picking up on some of the things that Nadia and Claire have said, this issue about how to apply the requirements in different rule of law environments. I suppose thinking about due diligence, the nature of due diligence is that it's a standard of conduct that and not of results, and it requires reasonable steps within your control, and it's context dependent. So when we think about due diligence in international law generally, because I've been looking at it in other contexts, for example, cyberspace, that's sort of very kind of core to the nature of due diligence, and I suppose that is inherent, therefore, in this context as well. But I'm not sure, I'm not as close to the directive and the text of it as you all are, and it may well be that that needs to be more spelt out, that there's this sort of a reasonableness and a capacity element to it. But I don't think that should at the same time get companies off the hook. I think when we think about weak rule of law environments and the kind of companies that would be in scope for this directive, and obviously we don't know that yet because the exact in scope provisions are still a draft directive, and those are part of the issues that are still being debated. There are several different proposals in the trilateral negotiations. But if we think about it, they're likely to be large multinationals, large companies with reasonably large turnover, and they're going to be operating in weak rule of law environments, possibly because they might get cheaper workforce there. They will get benefits from sometimes operating in that environment. That might be partly why they're there. And so perhaps all the more reason that they should be doing their due diligence. They have the benefits. This came out of the last seminar, but they don't necessarily have the obligations. And so those obligations should apply to them. But I appreciate that there is a sort of practical issue, as Nadia said, around like how do you get that information on the ground in those environments? Well, it is inherently difficult because by definition, there's often a lack of civil society. There might be a weak judiciary. There'll be less information available. Likely to be an independent media will be less likelihood of that as well. Much more government control. Well, first of all, as Nadia said, that might be a reason why the company should think twice about operating there, because the risks will be higher. But obviously, a lot of companies are already very invested in a lot of these countries, so it's not just a question of being able to pull out. That might be an option, but that needs very careful thinking through in itself, the idea of responsible exit. So then you have the question about what you do, and I think there is an argument, and we'll come on to this maybe in the next question as well, about due diligence being much more, as Claire said, holistic, addressing not just human rights, but also the rule of law and civic space. And that will involve working with human rights defenders on the ground, who obviously are very brave and do a great job, and often are still present in some of these really difficult environments, and working with, I think, some of these industry bodies which try to effectively become middlemen between civil society and companies, because often there's this sort of lack of trust and understanding between those groups, with the NGOs quite resentful sometimes of the companies there, and the companies not really knowing necessarily how to talk to the NGOs, or skeptical of what they're doing. So we're finding at Chatham House, part of what we've been doing is trying to bring different stakeholders together to talk to each other, and highlight things like the corporate human rights benchmarks, which some of these companies are not even aware of, and some of the industry bodies who can bring, act as a sort of middle ground, where, and also enable companies to work together in alliance in some of these difficult situations. So I think that was my main points, but I would say there's one other thing around the first question that was raised about whether or not the directive would impact the rule of law environment beyond the EU. And I suppose one way that ideally it might do so would be to be a sort of gold standard, which would have an influence on other regulators around the world, and the potential for sort of norm diffusion. We talked about how that might work through sort of supply chains, but also just in terms of actual regulation. There's obviously a big trend for mandatory human rights due diligence, so this could be looked at by others. And I think there are really important provisions in this directive about accountability and redress, including as well the prospect of civil liability, while also recognizing there's a big backlash against ESG and other things in the US. So I'm not suggesting it's going to be, taken up as a model by many countries, but hoping that it will be giving a lot of food for thought for other countries that are thinking of regulating in this area. Thank you.
Thank you very much, Harriet. Does anyone from our speakers want to? Yes, Bogdan?
Thank you for inviting me. I just wanted to say a few words about the impact of the directive on the rule of law environment beyond the EU. So to me, it's quite clear that the directive was intended to make this impact beyond the borders of the European Union. And the very concept of the value chain is an evidence of that, because through this concept, we actually say that the corporate actor is responsible not just for its own actions, but also for the actions and operations of its partners. And so in many other articles of the directive, we can see indications that it is intended and it is meant to create the effects on a global level and outside the EU. In particular, it says that if a corporate actor see that there is nothing it can do to make the situation better, to prevent the risks or mitigate the risks or bring the risks to an end, then this corporate actor is required to terminate their relations with the partner. So, and of course, it will influence that partner, because that partner will lose the market. And of course, those partners will have to battle for the markets, and they will be forced to follow the human rights standards. And the last thing I wanted to draw your attention to, which very expressly says that the directive will have impact beyond the EU. In one of the articles, it says that if the directive is adopted, it will be the overriding mandatory rule, which is very interesting as to me, which means that if we have two companies concluding a contract, and one company is from the European Union and the other is from some third country, and in their contract, usually they are allowed to choose the law applicable to their contract. So choice of law clause. And if they insert a clause in their contract that, for instance, we want our contract to be governed by the law of the third country, so even in this case, notwithstanding that they have made an express choice of law, the directive will be applicable. So that's a very interesting effect. So there is no doubt that this effective will be applied extraterritorially in some sort of way.
Thank you very much for your comment, and I'm giving the floor to Yarnay.
Thank you, Tamara. Good to see you all. Thank you for invitation. Yeah, I mean, Tamara, this is a very difficult question you ask, and one has to look at this question, at meta level, because it's not only a business and human rights question whether the impact of the directive will be visible in a short, medium, or long term, but it's a question about the role of the EU. Some of you will remember just a year ago, Josep Borrell, High Representative for Common Foreign Security Policy of the EU, had a speech at the College of Europe in Bruges. And there he made a controversial remark. He compared EU and the rest of the world. He made this metaphor of a garden and a jungle. But it's I mean perhaps the metaphor was inappropriate. But I mean he tried to pinpoint on the fact that majority of the parts of the world do not subscribe to the basic principles which are applicable in the EU. Among them, most of them, rule of law. Rule of law, which is a principle which, in effect, is very, similar, very to the heart of business human rights, because both of fields, business human rights and rule of law, they have to do with power, the notion of power, and how to curtail the power. And if you take, the UN member states, perhaps a third of them is based on rule of law, and constitutional democracy. And then, try to argue that the directive will have impact beyond the EU. It's quite, I would say it's quite optimistic. Of course, I agree with Nadia that the directive, when adopted, should apply equally all around the world. But then, of course, if you have, as in many parts of the world, business interests colliding, colluding with government interests, then we have a lot of challenges, where trying to advance due diligence in global south, but not only in global south. I mean, also in parts of Europe, which are close to Brussels, Paris, and London, the ivory towers of Europe. It's very hard to argue that the impact will be visible in the short term. Particularly because of the facts in the regions beyond Europe, governments are not very much committed to business human rights, of course, with some exceptions. But then, of course, there are also evidence to the contrary. From Western Balkans, we can see from some countries that foreign investors, such as those companies which are based in EU, they're already complying with the EU law on non-financial reporting and other business and human rights standards, and they're really pushing the governments. For example, one of the best examples in this regard is Republic of Serbia, where the government has not been doing much in the recent years, but then the business sector and civil society has been really pushing the envelope, particularly the Serbian Chamber of Commerce. And to me, the question is also how far will this geographical area, extend where EU companies can use and exercise their leverage, given the diminishing influence the EU has in the world. It's a question which is very much connected also to the role EU plays in the world. So one has to be realistic when we talk about rule of law and potential impact of directive. Of course, equal standards, but then perhaps other tools, more softer tools, have to be used in order to persuade other countries, in global south, to get on board and try to advance due diligence standards. Because in a country, where there are weak institutions, where there is a weaker rule of law, where there is no access to remedies, it's very difficult to imagine that the impact of the directive will stretch beyond of just ticking the box for civil society and academia of the global north.
Thank you very much, Jernej. Do we have still comments on the first question from our speakers? Yes, thank you very much, everyone. And I think it's really important that almost everyone raised reflections on the universality on human rights, legal regulations, yes, and even on due diligence directive. Especially, we see it even from comments in our chat, and Alana mentioned the question whether we can perceive the CSDD as a public order regulation or only private regulation. And the question then rises how universal can be all the procedural tools in the human rights sphere and how they can apply it on the universality basis, or we need to take in account our different environments. And actually, it was mentioned by Harriet by questioning the whole aim of CSDD and the whole aim of the set of tools we apply to count corporations. And actually, it's a great transition to our second round and second questions about applicability, the same due diligence tools to the different impacts corporations can do in different environments. So because we don't only talk about human rights abuses, yes, but we are also talking about following different regulations and principles of international law, especially of the rule of law requirements. So if can we perceive the CSDD tools and due diligence requirements not only for preventing, mitigating, and redressing human rights abuses, but also abuses of rule of law, or let's say that the requirements of rule of law can also be managed in corporations through due diligence requirements. Yes, the floor is open for comments of our speakers. Yes, Nadia.
Yeah, thank you for this. Thank you for this question. Actually, of course, we had the questions before, just to tell the audience here, so we have time to think about them in advance. And I'm really grateful for this, because this one I had to think about it for quite some time before I could gather some ideas that I was happy with. So the proposed directive is will ask companies to identify their human rights impacts and mitigate their impacts, etc. So that's the UN guiding principles language as well, more or less. And also under the United Nations guiding principles on business and human rights, companies are supposed to have policy commitments. They're supposed to have a human rights policy We always talk about due diligence, but there's more to business and human rights than due diligence. And there's also in the guiding principles this idea that companies should have human rights commitments. So I suppose the question is, should we now ask them to also have rule of law commitments? And what would be the difference between the two? So first of all, I will say this, it does sound a bit strange to me to have rule of law commitments. I know we're trying to break ground here with this series of talks about rule of law and corporate actors, because by definition, those are not issues that are discussed together. So I am all for breaking this new ground. But I have to say that rule of law commitments sounds a bit strange to me because, of course, the rule of law is a concept normally associated with public law issues, constitutional law, separation of powers, having a government, a parliament, a judiciary, an independent judiciary, all these kind of really public law discussions. So having rule of law commitments sounds a bit strange to me. That said, I am really all for looking at corporate accountability as broadly as possible. And in this, I was thinking about this rule of law idea and what does that mean for a company to contribute to the rule of law. And actually, if you look at not the guiding principles, but the OECD guidelines on multinational enterprises, especially the revised version now, the 2023 version, they really go into issues that are very connected to the rule of law. So, for example, they talk about bribery and corruption. Now, when a company uses bribes, or when a company has to pay, when there is corruption in the environment in which they operate, that interferes with the rule of law, because corruption is interfering with a fair standard and fair processes for everybody. And similarly, anything that has to do with transparency is also contributing to the rule of law, in which you want predictability and all these issues of let's say, good governance. And there are also other examples of issues that to me are related to the rule of law and also connect to corporations and how they behave. And one of them is investment arbitration, where we see entire parts of litigation that actually are completely taken away from domestic courts and go into secretive courts that citizens know nothing about. That to me is a problem from the perspective of the rule of law. And when companies benefit from these kind of rules that are not for everyone, but just for them, that to me is a problem from the rule of law perspective. So I don't think that companies should have rule of law commitments, but I think it's good to think about corporate conduct more broadly, to think about the impact that corporations have on rule of law environments. I think the OECD guidelines, especially of 2023, is a very good starting point to get a better idea of what good citizenship would mean for a company. But I think there are also other areas we could think about that connect to the rule of law and in which companies can play a more active and positive role than they currently do.
Thank you very much, Nadia, for this interesting perspective. And we also have two raised hands. So maybe Yerna is first and then Harriet.
Yeah, thank you for your question. I think, I mean, rule of law commitments by the companies are given effect, because companies as legal persons, as legal subjects in any legal order, they have to comply with the rule of law, with constitutional requirements, with the legislative framework, and so on. So there's nothing new in that, but here we are gathered today in this talk on rule of law and due diligence and corporate actors, and indeed this is an area which those are the areas which have not been examined together so far. It's really under research area, even though they're very very similar, particularly in some regions. Business related human rights abuses in some regions are very much connected to the rule of law abuses, particularly if you look at countries such as Central Asia, or regions such as Central Asia or Central or Eastern Europe, but also Global South, Sub-Saharan Africa, Asia, Latin America. We see a lot of examples where businessmen or large corporate groups are trying to influence the rule of law in the country, either by owning the largest corporations, or taking over media corporations, and thereby influencing elections, and also consequently also the formation of the governments and all branches of the government. So the issues are very much connected, and definitely rule of law. Myself, I don't consider rule of law strictly in these legal terms, about legal predictability, foreseeability, legal certainty, and so on. But I think that rule of law is a notion which describes absence of arbitrariness, not only in a public sector, not only in the government, but also in a private sector. And of course, a challenge arises where public and private sector collide to advance, private interests, which often result in business-related human rights violations. We have been seeing since February 2022 a textbook example of that, where different companies from Russian Federation, which are mostly state-owned, controlled by the government, controlled by the cabinet or the president, have been, taking part in the hostilities. Some of them even, creating their private military corporations, taking part in the combat on the ground. But it's often a fact that that businessmen in weak rule of law environments, they try to take over also the government, different branches in the government, in order to advance their own interests. And therefore, of course, human rights due diligence as a part of rule of law in many jurisdictions has a role to play. But I take human rights due diligence as a part of rule of law as a means also how to ensure that the private sector, but also state-owned companies, do not abuse rule of law for their private gains. There are so many examples, from different countries. You guys from Ukraine, you're aware of politicians entering the politics, winning the elections and trying to bend the government and rule of law in their own way to their own private interest. We have, unfortunately, an example here in the European Union where a prime minister of a country, of a Republic of Hungary, is very much connected with the largest and most influential corporations which do business in Hungary, but also elsewhere in Central and Eastern Europe. So often businesses collide with the governments in order to advance their own interests. And of course, rule of law has the role to play also in business and human rights. And I hope to see more research in this regard.
Thank you very much, Jernej and Harriet.
Yeah, thank you. I think the question itself talks about whether companies should have rule of law commitments. And I sort of share Nadia's sort of queries, I suppose, about commitment, the word of commitment, and if we're thinking about it as part of like a directive or legislation. But I do think conceiving it in a broader way about support for the rule of law is definitely something that I think companies should be buying into and doing more on, actually. And we've done quite a lot of work and are doing quite a lot of work on that at Chatham House, not just the rule of law, but also the concept of civic space. And that's in the against the background, of course, of a great erosion of the rule of law and civic space over consecutive years. I think Freedom House has found, that democracy's been sort of gradually eroded, and for the last 17 years, civic space has been eroded. And Janusz mentioned a few examples. Hungary, also the judiciary has the powers of the judiciary have been weakened in Poland. There are attempts to do that in Israel. And the reason I think that links to companies is that the rule of law is that, we know it's like a check or balance on power. It sort of is a check against government control. And companies benefit greatly from the rule of law, from it's like the underpinnings of a stable business environment. So if they really want to sort of have a secure environment that's not corrupt, that is transparent, there are great benefits to them of a rule of law, a good, strong rule of law. And I think increasingly they recognize that. So, for example, a couple of case studies we've looked at, one is Israel. I know obviously Israel's in a very difficult situation. The whole situation is on a much worse scale now. But when we just look at the reforms that the Netanyahu government had proposed and the reactions to those by business, a lot of venture capitalists pulled their money out. 20 billion left Israel since December, when the proposals to change the powers of the judiciary were instituted or proposed, and there are obviously lots of protests as well. Similarly, in Hong Kong, we've seen in the last 5 years that the rule of law has gradually been eroded. That includes the powers of the judiciary, the independence of the media, and the ability of NGOs to operate, because of the way in which particularly the national security law has been implemented. And that has got business really scared. The Atlantic published a big report on that called Fractured Foundations. Businesses are often quietly moving their money out of Hong Kong and into other places like Singapore or Tokyo because they're worried about the rule of law, which Hong Kong was so vaunted for. It was partly because it was part of the the old imperial system or whatever, and it still is linked to that. So I think there's a clear benefits to business and companies of having strong rule of law, and they react badly sometimes when that gets eroded, but it's not necessarily part of sort of their commitments formally. What I think needs to happen is there needs to be more linkage. So, for example, the SDG 16 business framework, which was launched by the UN Global Compact in 2021, encourages business to embrace transformational governance by supporting peace, justice, and strong institutions, which obviously includes the judiciary, strengthening multilateralism, and reimagining the social contract. So sort of thinking more about their relationship with societies with which they operate. And I just sort of see rule of law as a part of that puzzle. And I think when we look at what companies are doing, there are obviously human rights statements. Some of those companies are now including the rule of law explicitly in their human rights statements, in their human rights policies. And groups of investors often come out with statements in relation to conflict issues like Sudan or Myanmar, and they will call for a restoration of the rule of law. Even in the US on the January 6th riots, there was the sector started agitating for the restoration of the rule of law, because they knew that this sort of situation in the US, which continues to be somewhat fragile, it's bad for business as well as bad for society. So I think I put in the chat a paper that we published recently, and it really focuses on investors rather than companies, but it seeks to make the argument, which applies to both of them, that they need to sort of widen the lens, take that more holistic view about the societies with which they interact, and think about human rights due diligence as part of a bigger picture of the rule of law and civic space, because they are increasingly influential actors. They have great leverage in many situations. But my final point would be that when we think about companies and the rule of law and the work we're doing, quite often the phrase corporate foreign policy arises, the idea that companies really need to, as geopolitical stakeholders, think about their responsibilities. That sounds, interesting, but it has to be, I think, thought about with care so that companies don't act unilaterally when it comes to the rule of law. I might give the example of Elon Musk and Starlink in Ukraine making decisions about, the ability of the Ukrainian forces to operate, drone attacks in that case. There needs to be some companies need to act in concert with governments. They need to be guided by governments. They need to be guided by human rights law when they're thinking about these issues. They don't operate in a vacuum. So I think that raises a much bigger question, as I say, about corporate foreign policy and where the rule of law might fit into that. We've got a few other publications which I'm happy to share if of interest, but I think this is a really interesting question that I'm hearing a lot more people talk about. So thank you very much for spotlighting it, and I look forward to hearing what everyone else has to say.
Thank you very much, Harriet, and I think everyone will be happy with you sharing with us all resources regarding the topic, and we're excited to read them. Yes, thank you everyone, and it's really a question the much bigger idea and the much bigger space, it's just business and human rights, and we see how business is interrelated with societal issues, with global emergencies, and with the question of accountability not only for the direct actions and direct human rights abuses, but contributing to them and participating in different societal contexts and in different environments. And actually, the way that Harriet explained how businesses and corporations try to avoid legislation, yes, and to overflow and to redirect their investments in different environments. And actually, on the one side, it questioned the strong rule of law, yes, how companies and corporations try to avoid really strong rule of law environments where the requirements for the accountability and responsibility are much higher. And also it questions, on the other hand, Nadia's comments about access to remedies and fair access to remedies, which is actually through the creation of different procedural and different institutions and different instances of addressing and accessing judicial remedies, actually questions our next third round of discussion, which interrelation of access to remedy within business and human rights area and access to justice is rule of law sphere, because they are extremely interrelated and extremely important, because without each one, it should be very hard to reach access to justice and access to remedies. So I just please ask you to share your opinions and ideas of how strong is that correlation and how far we can say about the core and direct interrelation of access to justice within rule of law and access to remedy within business and human rights area. Yes, Claire?
Yeah, I'm happy to start the discussion. So here I think it's really important to recall that access to remedies is really both part of the state duty to protect, but also the corporate responsibility to respect. This is very clear from the UN guiding principles, but I think it's really important because here we have responsibilities and duties that are of both actors that are really important. The UN guiding principles clarify that it is an integral part of the state to protect against business related human rights abuses, to make sure that they have the appropriate state, and that includes through judicial, but also administrative, legislative, etc., other means, to ensure that those effective have access to remedy. And it also talks about the need to alleviate the barriers that victims face. And we do know that there are a lot of barriers that are faced by victims to actually obtain access to remedy. And there are many studies that sort of highlight these barriers. In one of the ones we did for the European Parliament, that was in 2019, where we looked at 35 cases that were brought in the EU over a period of 10 years on the basis of alleged human rights and environmental harms that occurred outside of the EU. We only found out of these 35 cases that one gave rise to a successful judicial outcome. Some of them were settled out of court, so we may have also a discussion as to whether that also is something that is positive. Of course, the victims did get something out of it, but from a rule of law perspective, that also raises some concerns on my part. But through the judicial system, we only had one positive judicial outcome, and we did identify many barriers to access these legal remedies that were faced by the claimants, from procedural to legal barriers to practical barriers, etc. And so here there is a real need to work on alleviating these barriers to ensure better access to remedy, also as part of the kind of more general rule of law principles. But as I mentioned, it's also important to see that corporations have also an important role to play in relation to remedy. It is clarified in the UN Guiding Principle and in the OECD guidelines. The UN Guiding Principles explain that the corporate responsibility to respect human rights means that they should avoid infringing on the human rights of others, but they should also address the human rights harms with which they are involved in. As part of that, that if they have caused or contributed to adverse impact, they should provide or cooperate in remediation through legitimate processes. Now here, the question that arises, and that links to what Nadia was saying earlier about investor-state arbitration, is what are these legitimate processes? How do you define them? For instance, there are some rules that have been developed around business and human rights arbitration. Is that something that can also guarantee that the sort of rule of law principles that are upheld, if that is being used? And what about the idea of the risk of privatizing justice? Is that a risk that is that raises issues in terms of rule of law? Sorry, I'm raising more questions than I'm answering here because it's a very complex question, and I'm happy to hear also my co-panelists on these issues. But I just wanted to sort of mention that among these areas of alternative dispute resolution mechanisms, some questions that concern rule of law may also legitimately be raised there. And I will stop.
Thank you very much, Claire. I think sometimes right and right question is much better than quick answers. Thank you very much. Does anyone from our speakers wants to add to the discussion about access to remedies? Yes, Bogdan, please.
Yeah, I just wanted to add a few words, building on what Claire was saying, is that yeah, today we have a great number of alternative dispute resolution methods. And of course, we expect from the companies to introduce their online platforms for dispute resolution. But yeah, at the end of the day, the ultimate remedy is provided by the court. So, and to tell you from our Ukrainian experience, for many, many years, we have been believing that if you have some troubles, if you have some dispute, you have to go to court. And the alternative dispute resolution methods are just starting to evolve in Ukraine. So, and your positions in negotiation, mediation, facilitation, whatever, are much stronger if you are backed with the possibility to go to court if you are not satisfied with the solution. So therefore, absolutely, there are no doubts that access to justice is a very powerful tool in fostering the human rights due diligence, apart from all the other alternative dispute resolution methods that are applied now.
Thank you very much, Bogdan, and I see Yevney.
Yeah, of course, access to remedy in business human rights and rule of law are very much connected. You know, I mean, this has been one of the challenges for all of us working in business human rights, how to advance the field and how to make sure that rights holders have effective access to remedies. Now, we all know that in business human rights, only few jurisdictions provide proper access to remedy, due to the fact that the rule of law in most parts of the world has been deficient, weak, and often subject to different kind of interests. If a country doesn't have independent, impartial, fair institutions, then it's difficult to talk about access to remedy. And then, we turn to another problem in business human rights, that what does it say for a field that rights holders have to go to the courts in UK, Netherlands, USA, Canada, and some other countries to enforce corporate accountability for business-related human rights abuses? It's there's a lot of what can be said about that from the perspective of colonialism, imperialism, and other aspects of critical legal studies. And I just want to mention here one case from European Court of Human Rights, which was decided some years ago. It's a case Osman and Amirgyan versus Armenia. It's about expropriation of property in order to extract mines and natural resources by a semi-state-owned and private-owned company in Armenia. And this case, in my opinion, really shows all the challenges we face, because the case went to the European Court of Human Rights, where the applicants were advancing the argument that Armenia felt its positive obligations to make sure that the right to property has not been abused. But the court, in the judgment, confirmed the arguments. It upheld the arguments and said that the Armenian courts have not properly dealt with the issues. They were not independent, impartial enough to solve the case in the domestic system. And basically, this case, as many others, outside the Council of Europe area, the show is that in business human rights, and this is also one of the hopes of civil society with this directive, proposal of directive, which I think, in my opinion, is perhaps utopian, that the directive will improve corporate accountability for business-related human rights. First thing we have to do, is to improve our domestic legal systems, that rights holders will be able to enforce corporate accountability. If we don't have independent and impartial and fair judges, then all discussion of access to remedy in business human rights is futile.
Thank you very much, Yernay. Nadia?
Yeah, just want to add something, just to react to what was already said. It's very, very quick point. Just to come back to the proposed directive, the Corporate Sustainability Due Diligence Directive, I think it's very clear when you read the text that it isn't about access to remedies. Yes, there is a liability provision there, but there is nothing about facilitating access to remedies for potentially affected rights holders. The draft is more like a corporate law piece of legislation. It's about asking companies to do this and that, but it really isn't about accessing remedies. Because as we know, and I think all the speakers have said that in this round of questions, it's not because you have a legal avenue that you have a remedy, because the obstacles to access remedies, first of all, the fact that people have to go to Europe to have some kind of access, some kind of remedy, is a problem in itself, for sure. and there's all sorts of wrong with that. But also, even if assuming that people that affected people go to Europe, I mean, for many vulnerable communities, the fact that there is a legal route doesn't mean it's possible. I mean, you might as well ask them to bring a case to the moon. I mean, it's just impossible to conceptualize. And I think I'd like to see more work. Perhaps there is already work on that I'm not aware of, but how you turn a business and human rights violation into an actual case, like this work of transforming a societal issue into an actual case, and then the chances of this being accepted and leading to some kind of settlement. I would say a settlement is a win. I know we could discuss that from the perspective of the rule of law, but let's include settlement as a win, as well as positive decisions from courts as wins. Still, that's very few. And there's all sorts of issues there that are absolutely not touched upon in due diligence legislation, whether in the directive or even in existing due diligence legislation, such as the French one, the French law and the German law and the Norwegian law. None of those actually say anything, I would say, of substance to address that issue of access to remedies. So that's really where the due diligence discussion is further removed from rule of law, I would say, in this question of access to justice, access to remedies.
Thank you very much, Nadia, for these interesting considerations, and I give the floor to Harriet.
Thank you, Tamara. Just a quick point, because this isn't really my natural area, but it struck me that there's obviously a lot of challenges. Maybe one, not ray of hope, but sort of more positive development has been the development of strategic litigation in the climate context, which is really ramping up in the last few years. And I have done a bit on that, and I know that one of the ways that happens is by looking at the disclosures and statements that companies are required to make, partly under the ESG framework, and then holding them to account and when they fail to basically carry out their plans or commitments. And the same, obviously, with the litigation against governments. And it's very early days, but some of that litigation is quite creative and thoughtful, and there's a big impetus around NGOs seeking to bring that kind of litigation. And when we were just linking it back to what we were talking about with rule of law commitments, insofar as companies make statements about human rights and about the rule of law and then don't live up to those commitments, then that's all sort of grist to the mill. That's all useful stuff for potential litigation, because you actually have something in writing that they said they were going to do. That doesn't get past the hurdles that the learned speakers have raised, but it's an interesting development that we should keep an eye on as well.
Thank you very much, Harriet. And as we see from discussion, the main point is the effectiveness of different remedies and different tools which can or not provide effective access to justice and to remedies for victims of corporate human rights abuses. And in this regard, we were talked about climate litigation and mediation and other types of remedies. And in this regard, I have one additional question to Bogdan regarding tort law. Especially, how do you see whether the tort law provisions have the effect and impact on bringing corporate actors to effective respect of human rights?
Yeah, thank you, Tamara. So I consider myself to be a scholar who addresses the issues of tort law. And yeah, I believe in the potential of tort law, because tort law is a very overarching branch of legal rules, which are revolved around a very simple idea that the one who has caused the damage is obliged to compensate it. And this rule equally applies to corporate actors as well. And we can also consider this issue from the perspective of law and economics, which very brightly illustrates why tort law can be useful in this regard. So from the perspective of law and economics, tort law is a way to make corporate actors internalize the costs they settle on the society. So if we, for example, imagine a company which produces some chemicals and pollutes the environment, and all the people who live in surrounding areas, they suffer from different illnesses, they suffer pain, and they have to incur some costs to medical treatment. So from the perspective of economics, these costs are costs of the end product, but they are not borne by the producer of the product, but rather they are borne by the society itself. And the goal is to make the producer of the product to internalize those costs, because so far those costs are external and they are called externalities for the company. So the company has to internalize those costs, and the tort law is the way to do it. And only if the company internalizes the costs that it creates for the society, only in this case, it would have sufficient incentives to change its behavior and to introduce new policies that would be safer and that would not inflict damage on the people. So yes, the answer is yes, tort law could be used and should be used as the venue to hold corporate actors accountable for human rights abuses. And I do believe that tort law can affect their policies. However, we have a few obstacles or a few hurdles on this route. Namely that in a tort law doctrine, we have elements of tort that have to be proven. And with regard to human rights abuses by corporations within their value chains, sometimes some elements of the tort are very difficult to prove. In particular, it's, by the way, the concept of tort and the list of elements of tort, those are different in different jurisdictions. But in general, we speak of duty of care, breach of duty, damage, and causation. In particular, with regard to the duty of care, it is always an objection that a company can raise that we have nothing to do with the abuse of rights that you suffered, with the damage that you suffered, because that was committed by our supplier and not by us. And we have the principle of personal responsibility. So the fact that our supplier violates human rights should not touch upon us. However, the instruments like the directive we've been discussing today, they can change the situation, and slowly the paradigm is being changed. And now we recognize the liability or responsibility for the actions of others. And so in this way, I can think that we can strengthen the rule of law through the means of tort law and through tort litigation.
Thank you so much, Bogdan, for this thoughtful and interesting, deep insights about tort law effect on the responsible business conduct. And Claire, please.
Yes, thank you. I just wanted to make a quick comment based on what Bogdan said. I completely agree with the importance of the role of tort law. The difficulty, and here I agree also with what Nadia says, it hasn't been addressed at all in the CS3Ds as part of the kind of general access to remedy under the general access to remedy umbrella. The difficulties are going to arise from private international law principles. And here I'm thinking in particular about an example, which is a Chevron case, right? So this is a case that was brought in the US in relation to the activities of the American company Chevron in the Amazon that was polluting the Amazon and affected the life and livelihood of the indigenous communities there. The US court used a doctrine of forum non-convenience to say we decline to exercise jurisdiction. The case went to Ecuador, where the victims, where the harm occurred, the victims were based, etc. It was successful in Ecuador in the sense that Chevron was sentenced to $8 billion. But then, of course, the majority of the assets of the company, being an American company, are the US. So the question arose about the recognition of that judgment in the US. And that never occurred because the Chevron then said that the judges were corrupt. So here we're in the middle of the rules of law issues, right? They say the judges in Ecuador were corrupt, the judgment was not valid, and the judgment was never actually recognized and enforced against the assets of Chevron in the US. So the issues that we need to overcome in order to ensure that tort can play that role that Bodin was just talking about, that is absolutely crucial, I completely agree, are private international law issues. And until we have addressed these issues, we're not going to be able to guarantee to victims and right holders that they have access to legal remedies, because they will be facing constantly this sort of hurdles.
Thank you very much. Thank you for this interesting point. And I just have one small follow-up question for Claire. But do you think in this regard, if one jurisdiction initially refused to consider the case at all, does it internationally, of course, we don't have clear principles of that, but is it obliged to recognize the decision which was made by other bodies in other countries when they refuse themselves to make this decision? And are they able to criticize the decision in a case which they refused to consider?
Sorry, I missed the beginning of your question. So your question is which court are you talking about? So in that example, the US court, is the US
yes.
exercise jurisdiction or to recognize the case? Is that your question?
Yes, if the US court refused to examine the case, do they have the responsibility to recognize the case made by different country, or are there any guarantee?
No, there is no obligation to recognize a case. The doctrine of forum non-convenience, which is mainly used in Anglo-Saxon countries, is actually not allowed in the EU. We have a judgment from the European Court of Justice, the Obuzu case, that prevents that doctrine from being used in the EU, specifically because it raises a lot of issues and delays a lot the time that it takes for a case to be heard. And when we see cases that have been sort of successful on the preliminary issues and jurisdictions in the, I was going to say EU, but I'm going to talk about the UK, so this is not exactly accurate, but I'm saying, so broadly in Europe, we see cases like Vedanta that took 6 years, right, to be decided on issues of jurisdiction. So we still, and it never actually got into their substance because it was settled out of court eventually. But that is a big issue. But yeah, that doctrine is not allowed in the EU, but in the US they can exercise it to decline jurisdiction, and there is no following up obligation to then recognize the judgment of the other country.
Thank you very much, Claire. Nadia?
Yes, thanks. I just want to briefly address the point that was made in the chat by Catalina about the use of tort law and I would say of legal remedies in general to address, let's call them business and human rights issues. I think this is a really important point that is raised here. And it connects to what I was saying earlier. How do we go from these vague but very real situations of injustice that combine historical power imbalances, sometimes post-colonial contexts, severe human rights violations against particular groups, and then within these groups against particular vulnerable parts of the group, so such as women or others. And how do we, and should we even try to turn these issues into legal claims? Is that really the role of courts to do that? And is it also, I hate to say it, but is it also fair to bring these claims against companies when clearly the situations, the violations, they contribute, but it's part of a context that they have very little control over. So I made clear earlier that I think in those situations, companies shouldn't be there because they actually exacerbate the problems. But the reality is that they are there. And when they are, then is it the role of courts, especially courts in Europe, to deal with these much broader societal issues? So I think it's to use the language that is used in the chat here. Should we think about remedies beyond the payment of a damage? I think this is really essential to start doing that more than we've been doing. I know there's lots written on that already, and yet somehow it looks like, for example, in European courts, that's the only remedy that is being considered. I'm not sure about out-of-court settlements because, of course, we don't know exactly what the settlements are. I know some of them have included more sort of reparations beyond here is a check, but I think this is really essential. And then there's a difference between a remedy and a compensation and actual justice. None of that is in the directive, and that is a massive blind spot for me. This text to me is based on this fiction that companies operate in situations where everything works well, and therefore they do their due diligence and we solve problems. But this is not the reality in many contexts. So this is not enough, basically.
Thank you so much, Nadia. Yes, and actually it connects to overall and global questions on contributions and participations of business sectors in different human rights abuses, actually not only in one system or environment, but also in times of global emergencies. But we still have 10 minutes, so you can share your wrap-up comments on the overall discussion, and if someone wants to share about responsibilities of businesses in a global emergency such as human rights abuses in armed conflict, please, the space is yours. Done.
Yeah, just a few words before I will comment on human rights in war conflicts. I just wanted to add to what Claire was saying about the jurisdiction, because jurisdictional issue is, yes, one of the, I did not mention it, but it's one of the most challenging issues with regard to tort litigation in this kind of cases. And one of the perhaps most prominent examples how hard could it be is the litigation under American Alien Tort Statute. And we saw the rise and fall of that statute, and it shows and it focuses in particular on jurisdictional issues. And often it is the jurisdictional issues that become the ultimate hurdle, which could not be overcome in this kind of litigation. With regard to human rights violations committed in the armed conflicts, also, again, I would have to refer to Alien Tort Statute because there was a lot of attempts to hold corporate actors accountable for aiding and abetting human rights violations committed by foreign governments. And yeah, if you are interested in that kind of topic, you should probably consult this kind of litigation. That's a voluminous case law by American courts. But also, I recently came across a very interesting report which was prepared by the Genocide Network. And this report was called Prosecution of Sanctions, Restrictive Measures, Violations in National Jurisdiction. So what was the point of the report is that Genocide Network, they spotlighted a very interesting interrelation between violation of restriction measures and complicity in crimes against humanity and war crimes. And that's a very promising direction as to me, because we have now lots of sanctions imposed on Russian companies. And in this report, you can also find some cases that show how it could be done. Like in France, there are some cases, in Denmark, Belgium, Germany, Netherlands. So the point is that if we have sanctions which forbid companies to supply some kind of dual-use chips to Russia, and company violates this prohibition, and it is, on the one hand, it is a violation of restrictive measures imposed by European Union or whatever. But on the other hand, at the same time, this violation is a contribution to committing a war crime, because those chips will be used to build rockets and bombs, which will be used in the armed conflict. And so, yeah, there is also a room to use tort law and to hold corporate actors accountable. And the interesting breach that was mentioned in the report is that we can use the prosecution for sanctions violation in order to afterwards conclude that this company also not just violated the restrictive measures, but also contributed to the war of aggression through that violation.
Thank you very much, Bogdan. And I know that Nadia Bernas should leave soon. So Nadia, if you have some comments or final wrap-ups, okay, we can give the floor to Yevgeny. Thank you.
Yeah, just coming back to your last questions on the question on the tort law. I mean, when I have been researching and working recently on the directive, I'm sure a lot of you also noticed there are also like certain legal risks when talking about the provision of the proposal for the directive from the rule of law point of view. Just if we take proposed Article 22 on civil liability, that article at the moment, as it has been written, it's not waterproofed from a point of rule of law. It includes terms which are not usually applied in tort law or in a civil law, taken from UNGPs, terms such as impacts or another term, value chain. Those are not tort or civil law terms. So one can imagine what will happen if a directive will be adopted in such a form of Article 22. A lot of companies could use that, to their benefit when arguing cases in the courts. But generally, to conclude, I would say that this series of talks on rule of law and business and corporate actors is very much welcome, because it joins two fields which have not been connected in the literature, but also in civil society, in academia. Even though both fields, they have to do with the sociological term of power. So I hope to see more research from Olena and all of us on these connections between the rule of law and business and human rights.
Thank you very much, Yerney. And Harriet?
Thank you. I just wanted to finish. I think you alluded, Tamara, to the bigger issue of human rights in conflict and companies' responsibility there. And obviously that is very live right now, obviously in Ukraine, but also in the Middle East. And this is a sense of this kind of leaderless world at the moment, and companies part of that, but also feeling like they're kind of caught up and enmeshed in it. So there's the responsibilities they have, but some really difficult dilemmas often as well. And then there's things like the voluntary principles on security and human rights, which, you know, require enhanced due diligence of companies in these situations, but that's self-regulation. It's been interesting to see, I think, in the context certainly of the recent crisis in the Middle East, the dilemmas that social media companies are facing, or that they're grappling with. The EU, I think, is chastising some of the social media platforms for some of the content that's on there at the moment, and able to point to legislation and to point to the Digital Services Act, you know, some of the tools that they have. So sort of seeing those hard law in action, because self-regulation only goes so far. And then you'll be aware of B4 Ukraine, which has been, you know, trying to put pressure on companies to really think about, if they're still remaining in Russia, why they're there, and whether there should be an exit and how they can execute that exit, which has thrown up some quite difficult issues in practice, but very important to keep that pressure up, I think, and to advocate for it. So as a final point is that there is increasingly, I think, civil society working with companies to try and come up with statements to condemn violence and conflict, and to try and take a stand and maybe be a bit more proactive, at least in their rhetoric, and think also about how they act in practice. But thank you so much for having me. It's been a real pleasure to be on this panel.
Thank you so much, Harriet, for such an interesting thoughts. And also, if anyone else of speakers or other participants wants to raise questions or comments or rhetorical insights, please. Yeah, we are very grateful for your participations, and to all participants who subscribed for our talks, and especially huge thanks to our speakers who devoted their times and effort to speak about these complex and hard issues about correlation of rule of law and corporate due diligence. Thank you very much, and we are waiting and inviting all of you to our next talks, and the next one will be on 30th of October, so we are very happy to see you all again. Thank you very much.
Thank you so much.
Bye.
Thank you. Bye-bye.
Bye-bye. Thank you.